Good evening, everyone, and welcome to AJ 101 Criminal Law Online. My name is Tony Farrar, and I am your instructor for this semester. Just a few quick things of note. If you look on the slide right here down at the bottom to the left, you will see the name of the textbook. It's California Criminal Law Concepts. The edition is 2017. You could probably get away with the 2016 edition, but I would highly recommend the 2017 edition as it does have some updated information that you really need to know. Also, located at the end of each chapter within your textbook are a series of things that you can do that will help you as it relates to your quizzes and your chapter exams. So there are 4 different areas in there. The first one is a student review area of terms and definitions, and that's chapter specific, of course. And the second thing would be a series of true or false questions, kind of a practice test or practice quiz, and that would be great to help you study as well. The third area would be a series of short essay questions that focus in on some of the larger things that we're going to be discussing during the chapter. Not that one thing means more than another, but there are some areas that are a little bit more complicated, and these questions tend to focus in on those areas and will help you research those areas and add some context to the conversation that we're going over as well. And then finally, there is a terminology exercise or quiz, if you will, kind of a matching game where the terms are on one side and the definitions are on the other side, and you kind of match them together. And that's a really cool way to learn some of your definitions and some of the terms that are located within your book. Now, also, as you go through each chapter, you will find some scenario questions and things that are kind of like that. And what I don't want you to do is simply memorize the terms and the definitions. I'd like you to use your textbook, read the chapters, because I know you're all going to read all the chapters and all of you are going to have a textbook and you're all going to be great students. But reading those scenario questions will really help you add context to the larger areas of the chapter that we're going to go through. So it is really important that you have a textbook. So get the California Criminal Law Concepts. Again, you can get away with the 2016 edition, but I would highly suggest the 2017 edition because of a few changes in the law. So let's go ahead and jump right into chapter 1, which is going to be the scope and source of criminal law. Now, by way of introduction, the basic purpose of criminal law is to establish limits on certain human behavior or activity considered to be harmful to society. And now down below this, you'll see the definition of a crime. And there's a couple of different definitions out there. For this textbook, it's going to be crime is a social conduct considered harmful to individuals and to our institutions, and therefore made punishable by law. And you'll see in just a moment how these two kind of come together. Now, open your mind for a moment, if you will, and I'm going to go off on a 2-minute tangent here and kind of talk to you a little bit more about the entire scope of law and why we have it. So, laws are not about oppressing people or preventing them from enjoying life. Laws are the tools, you guys, that we use to build and maintain an orderly society. Of course, if each of us lived in a state of isolation away from all other human beings, there would be little, if any, need for criminal law or any laws for that matter. But obviously, we don't all exist as hermits. And in fact, we live in a very complex society requiring daily interaction with many people, many different types of people from different places with different backgrounds and different cultures. And think about that as I'm kind of talking through this introduction, if you will. Now, in such a society, each person really must know what he or she can or cannot legally do regarding those frequent contacts with or dealings with all of those other types of people. So in order to avoid what we're going to call here societal chaos, we have to have some rules to govern our activities. Now, that's why, for just kind of a very low-level basic example, we have laws for operating cars on our roads. Imagine if we didn't have speed limits or laws for left turns or red lights or texting while driving or anything like that. We would have a huge issue. So that's why we need to have some of those laws. Now, even in a complex society such as ours, if everyone did the right thing in relation to all other members of society, we would still need a few criminal laws, because unfortunately, there will always be some who will attempt to take advantage of others, who steal or rob or in one way or another violate the life, liberty, or property of others by force, fear, or fraud. And moreover, from a career type standpoint, the law tends to provide limitations and controls. It is obvious that professionals that are already in the system, like law enforcement, the courts, corrections, any of those areas, have to understand the law. And students preparing for modern day law enforcement, corrections, security, or any of those things must be well grounded in the fundamentals of criminal law. This foundation provides that framework within which each must function or basically work. So, I mean, we need to know the law as well in order to give us that balance, that foundation or framework. So let me kind of push forward a little bit and talk more towards this definition of crime. Historically, our first criminal laws came into being as a result of society's struggle for or to control those persons whose antisocial activity was destructive and not really desirable in that area where people wanted to live, because safety, stability, and integrity are truly necessary for the healthy growth and benefit of any community as a whole. Now, we may think of crime as a violation of the basic controls of society, and we may think of criminal law as necessary to deter misconduct and otherwise deal with those individuals who would disrupt society. But overall, criminal law is an instrument of social control. Without laws, criminal or civil, we would have no protection from the predatory whims of others, those that want to victimize us. And in order to, but finally, to kind of wrap this up a little bit, in order to gain the protection of society's laws, the law-abiding members, that would be us, must be willing to give up a small part of their freedom to do just as they wish at all times. Basically meaning we can't do everything we want all of the time because there might be some laws against us. So we have to give up a little bit of freedom for that. This is especially true when one individual's activities interfere with the rights of others. So, with all that being said, we may define crime as social conduct considered harmful to individuals and to our institutions, and therefore made punishable by law. Now, if you need some more information, there's a really cool website. It's www.nolo.com. And you can go there to find a lot of information, frequently asked questions about criminal law, criminal procedure, search and seizure, laws of arrest, and more. You go there in the upper right hand corner, you'll see a little thing that says search entire site. You type in criminal law, hit enter, and you're going to be good to go, and you'll find all types of really, really cool information. So enough on that. Now let's kind of move into Before we get to some of the new things that are happening in criminal law, it's always good to look back a little bit at how it got there. The origin and development of criminal law is kind of where we're going to go. Now, most of our early criminal law was based on custom or other recognized patterns of human behavior which appeared to be beneficial to the group as a whole. And even early cavemen developed basic rules to live by. So criminal law is almost as ancient in one form or another as humankind is on Earth. No doubt those early cavemen established some sort of basic rules as who would eat first, or who would tend the fire, or who would stand guard. And no doubt those who didn't conform to whatever rule or law was there were punished. And survival was based on kind of following the rules. And even today, laws pertaining to certain types of crime like theft, murder, child molest, or something were taught as taboos to our children way back when. And this was called like social restriction. So you can see here, taboos taught to children kind of equal to punishment. And that was that social restriction, if you will. And as society developed and continues to develop, but as society developed way back here, rules developed into a written form of law, because before that there really wasn't any written form of law. And the first written law was in the form of symbols chiseled into rock tablets or impressed on wet clay tablets, which were then baked in something that you could kind of like read or look at. Well, one of the most famous examples of early written law is the Code of Hammurabi. And this large stone tablet, which by the way is now preserved in the Louvre Museum in Paris, was believed by scholars to have been written in 1790 BC by King Hammurabi of Babylonia during his reign from 1792 to 1750. And so you're talking a long time ago, developed almost, 3,800 years ago. But you know what? We can trace many of our legal concepts and procedures back to this code, which is really kind of cool. And if you can go on YouTube and look at some videos of the Code of Hammurabi and where it came from, and you'll start to see that. You'll see judges and juries and written contracts and swearing in of witnesses, and even perjury as a crime. So we can look way back and see how some of these things kind of move forward. It's actually really cool. Well, some other influences that kind of, some other things, if you will, that influence the development of criminal law we'll look at here in a moment. While the bulk of our modern law is based on English jurisprudence, or what we call body of law, we have also inherited traces of Roman law, as well as French and Spanish legal concepts. And as civilization developed, we find concepts such as trial by jury emerging in early England during the 12th century. We also saw the emergence of representative government, that is, the election or appointment of representatives who were granted authority to pass laws. Now, these legislatures adopted new laws as society and modes of conduct change. So yes, we can even make new laws as we start to see things change. Now, and so it is today. Our California state legislature and Congress pass new laws and rescind old ones as the need for change is perceived. And we also find our courts placing new interpretations on old laws as well. So a couple of other influences, and then we'll kind of move on, would be the Norman or the French period. In 1066, William the Conqueror, a French military leader, conquered the British Isles and declared himself king. Now, William found various individual courts in existence, which were primarily dominated by the sheriff. Now, prior to 1066, no action had been taken by the various kings of Britain to reduce these laws to writing. Rather, they just allowed the sheriff to enforce various tribal or village rules as he saw fit to keep order. Kind of imagine if that would be how it was today. It'd be kind of crazy. Criminal courts, as such, were kind of unknown back then. Now William, however, demonstrated kind of a genius for organization. He gradually took measures to reduce the arbitrary power of the sheriff, and additionally, he placed all of the courts under royal control and issued a proclamation inviting the common people of the county to seek justice at his courts, and this had really never been permitted before. Now, in time, English courts became more centralized and uniform in their administration of law. And then we'll kind of move into the Westminster period, which is 1285 to 1500. Now, gradually during this period, procedures became more formal. As such, the known or general custom of the kingdom became a little bit more rigid. For example, to establish that a certain practice was a custom and therefore a law, lawyers found it useful to give examples and illustrations from their own experience. They also cited facts from other trials that they could personally recall. Now, what's really cool is these illustrations of what had been done before were not binding on the court, but you know what? They were forerunners of what we know today as a term called stare decisis, or case precedent, or simply precedent, which are things that the court, precedent is what the courts will look back on for guidance. Now, this is how this kind of came to be. We can look all the way back to this Westminster period and see the custom that led to stare decisis or precedent. How cool is that? Maybe not for you, but I really think it's pretty cool. And then we'll move on to common law. Now, as defined by Blackstone, common law consists of doctrines that are not set down in any written statute or ordinance, but rather dependent upon long-time usage for their authority, meaning that as time went on, these unwritten laws kind of gained strength, if that makes any sense. And common law is obviously much more ancient than statutory law. So, quick review: common law developed by judges through decisions of courts rather than through legislative statutes, and unwritten law based on custom, and which would gain strength over time. Well, what about common law in America and the adoption of that? Well, the first settlers from England formed agreements among themselves called compacts, which contained much of the common law of England and was adopted for their governance. And following the Declaration of Independence, many states incorporated into written law most of the basic principles of the old common law. Now, in California, and this can be different from state to state when you talk about common law crimes, but there are no common law or unwritten crimes in California. On the contrary, for an act or omission to constitute a crime in California, there has to be a couple of things present, and that's kind of what we're going to look at right now. So for an act or omission to constitute a crime in California, there must be first a violation of a written statute, okay? Not some common thing that's been going on and on and on, but it actually has to be written down, so a written statute. And, okay, not or, it's got to be both here, the statute must provide a penalty for its violation. So this would be specific to California. Well, so now that we have a little bit of background, we've got a little bit about the cool Code of Hammurabi, and we talked about the Norman period, the Westminster period, and about common law. Well, where do these sources of criminal law come from? So for criminal law in this country, our criminal law in this country comes from the following three primary sources, if you will. So the United States and state constitutions, statutes or laws passed by Congress, state legislators, and local governments, and finally prevailing decisions or case laws. Remember, we talked about that precedent, if you will, of the appellate courts in criminal cases. So again, you can see how those things have kind of went from way back then to where we're at now. Well, what about the federal and state constitutions? Because we've talked about constitutions a little bit. So the U.S. Constitution is the supreme law of the land. Now, we recognize the United States Constitution as well as the Constitution of our own state as the fundamental written law of the land. And these two documents provide the framework for our criminal justice system in that, one, they define and limit the powers of government, and two, they provide for establishment and maintenance of our court system. And as you start to get further into criminal law, you're really going to need to concentrate and know what we're going to talk about right now, and that's the Bill of Rights. If you're following along in your textbook, because I know you all have a book and I know you are all super diligent in doing all your studying and listening to these lectures, if you look at page 5, there's actually a section on the amendments, the first 10 amendments, which is what we're going to talk about now, which is the Bill of Rights. So the Bill of Rights are the first 10 amendments to the United States Constitution, and they were adopted in 1787 and ratified in 1789. And while they all have an impact to criminal law, there are two that have the greatest impact. And again, I'm not downplaying any of the other ones because they're all very, very important. But those that have the greatest impact will be the Fourth Amendment, which deals with searches and seizures and warrants and things like that, and the Fifth Amendment, which deals quite a bit with self-incrimination. So again, there's a lot of them that are very, very important, but these, the Fourth and the Fifth Amendment, are extremely important as it relates to criminal law. But take the time to go through the PowerPoint lecture that I did on the Bill of Rights, and I threw in the 14th Amendment as a bonus. So the first 10 amendments, the Bill of Rights, along with the 14th Amendment, all of you should know those, and it's very, very important that you do so. So what about that Constitution? That's the California Constitution. So, you know, we have the U.S., the United States Constitution. We know that is the supreme law of the land. But we also, remember, we just talked about that, the federal and state, the difference there. We also recognize, you know, the state constitution as well. So why do we have that? Why do we have like a United States Constitution, and then why do we have like a state constitution? Well, there's a reason for that, and we'll kind of talk about it. Our state constitution also begins with a declaration of rights, which reflects the same concerns as the Bill of Rights. So the California Constitution is one of the longest constitutions in the world. It does begin with a Declaration of Rights similar to the U.S. Constitution's Bill of Rights. It talks about the right against unreasonable search and seizure, and it talks about the right against self-incrimination. So the California Constitution plays a vital role in that process as well. So now that we've gone through some of these pieces, let's talk now about the purpose and nature of criminal law. Crimes are prohibited and punished on the grounds of public policy to prevent injury to the public. And injury to the public might include destruction or interference with government, human life, private property, or other valued institutions or interests. Now, such considerations as desire for vengeance or compensation for injury may also be involved. And punishment is often said to be the purpose of criminal law. And this is really only true to a point. The real purpose of criminal law, which we learned about earlier, is to define socially intolerable conduct and to hold conduct within limits which are reasonably acceptable from a social point of view. And you'll see sometimes in the lectures we'll go through, there'll be some case laws in here. In here you have Sire versus United States. And these are things that you could actually look up and get a little bit more information on what we're talking about. Now, perhaps it may be said that whatever purpose is served by punishment, one purpose is that of compelling persons to cease or refrain from committing crime and forcing or even persuading them to conform to established rules of conduct designed for the protection of government, life, and property. So that's kind of a quick overview, if you will, of the purpose and nature of crime. Well, so what is a crime? Now we're kind of to that part where we're going to talk a little bit about the definition of crime and what is it? Well, it's a public offense, and we'll talk more about what that is, committed or omitted, in violation of law, commanding or forbidding it, either one of those, when annexed upon conviction, meaning like when you get convicted, there's going to be a result. That result is going to be punishment, and that punishment is going to be death, imprisonment, fine, removal from office, or disqualification from office. Now, the terms crime and public offense mean the same thing and include things like felonies, misdemeanors, and infractions. So when you hear public offense, that could be any of those three. And the word crime in itself, more extended sense, if you will, includes every violation of any public law. And all public offenses or crimes in California are statutory. We learned that, meaning they're written, and the court cannot have recourse to common law to determine prohibited acts. So remember, we don't have that common law thing in California. So hopefully it kind of clears that up. And then we're going to move to this phrase called stare decisis. But really quick, let me go back to well, no, we're going to stay here. So it's pronounced stare decisis. People pronounce it a few different ways. And the meaning really kind of means adhering to the precedent. And precedent is important to understand that a court often makes its decision based on previous court decisions called, excuse me, precedent. Courts, especially intermediate appellate courts, try to rule consistently with past precedent in order to maintain an orderly system so that people will know that conduct is permissible and what is not. So you can see the importance of stare decisis, or case precedent. And we read about kind of how that evolved all the way back from where, if you remember, I think it was the Westminster period that we talked about. So previously decided cases have great impact and influence on the decision of current cases. And this provides for consistency in law. And does that mean, well, that we can't depart from that? Well, not necessarily. Courts do not always have to adhere to precedent. There are times when the court sets law into a new or modified direction. And this may be due to new facts in current cases. So most commonly referred to as new law is made not so much departing from precedent, but because new facts are involved. Every case has something about it that is different from any situation which has maybe gone before it. And it is the application of the Constitution or statutes to these different factual situations which typically results in new law. So that's just, I mean, it's kind of cool when you look at that. So what are some classifications of law? Well, criminal law may be classified into two broad categories. It's either going to be substantive law or it's going to be objective law. And we're going to kind of look at the difference between that. Now, substantive criminal law may define activity or behavior that is either prohibited, like theft or assault, or required, like paying child support or registering your car. It is obviously a crime to do that which is prohibited by law. It's also a crime in some cases to fail to do what is required by law for one to do, if that kind of makes any sense. Substantive law can further be defined as that part of the law which the courts are established to enforce, as opposed to rules which would be more under the procedural or objective law, and that's where we're going to go to now. So that adjective law refers to rules for administering the law. And one kind of easy example would be rules for police when submitting evidence to court. That would fall under that procedural or adjective law. And hopefully that kind of makes a little bit more sense. So peace officers need some understanding of adjective law or procedural law, because it does include things as rules of submitting evidence to court and arraignment of those charged with a crime. Adjective or procedural law is also concerned with carrying out of court orders, redress, or another word for compensation for injuries, and classification of crimes and punishment. So you can see that the difference between those two classifications of law. Well, now we're going to talk a little bit about criminal law versus civil law and some of the differences there. So criminal law versus civil law. Well, criminal law, as the term implies, concerns itself with defining those specific acts and omissions, meaning failure to act, which constitute a crime in our society. Now, we know the penalties, and they're listed here again. The penalties can include death, prison, fine, etc. Where can you find these? Well, you can find them most commonly in the California Penal Code. However, there are a ton of other codes out there, like 40 other various codes, and I'm not going to list them all, but could be the vehicle code or the education code or the welfare and institution code or health and safety code. And those are things that are more applicable to criminal law. Now civil law has to do mostly with describing or establishing rules for various legal, mostly business, but not all of them, relationships, contracts, and other types of agreements. And violation of civil law, they're not misdemeanors or things like that. They're called torts. And the remedy, typically for civil, the remedy is handled by some type of fine, be compensatory or punitive. And some other differences that kind of come along between the two, if you were to have a civil trial versus a criminal trial, if we're going to compare the two, would be the degree of proof required. So for a conviction, let's say in criminal law, and we'll learn more about this down the line, you need proof beyond a reasonable doubt. Well, you don't need that same degree of proof for civil cases. Same thing when it comes to jury votes required. You may need 12 jurors all to say guilty or non-guilty in a criminal case, but you don't need the same for a civil case. So different amount of jurors, maybe different amount of juror votes, and even some of the applicability of rules of evidence. There are some differences between civil cases and criminal cases, and we'll learn a little bit more about that in some of the future chapters. Well, what about this thing called statute of limitations? Well, the statute of limitations, basically, it places a limit on the amount of time which may legally pass between the time the crime was committed or discovered and prosecution is started. So By way of introduction, it is necessary to consider the statute of limitation on certain offenses in order to know how long after the commission or discovery of a public offense a suspect can still be prosecuted. In some cases, the time starts running from the time the crime is discovered. In other instances, the statute of limitation starts running when a crime is committed. There is a difference as to the statute of limitation between felonies and misdemeanors, and there is also a difference in the statute of limitation between certain felonies and between certain misdemeanors. So an example could be the statute of limitation for a misdemeanor, let's say for theft, could be a year. So if that theft has, if it's been longer than a year, the thought would be that you wouldn't be able to prosecute that person because the statute of limitation has exceeded itself or passed, if that makes sense. Some crimes do not have a statute of limitation. One specifically that we could talk about could be murder. So I'm not going to go through all of those. I will let you read some of those in your textbook, but if you're looking for a reference case law, you can look down at the bottom here as well. There's some other sections that are listed here where you can kind of look. So misdemeanors have a 1-year limitation. General felonies have a 3-year limit when you're talking about statute of limitation, but there are some sections and some other things that you can look at on this particular slide that kind of give you a little bit more information as it relates to that. So now let's kind of look at case citations and appeals. And why am I even kind of showing this? Well, one reason is I want you to be able to look up a particular case, and another reason is because it's important as it relates to cases being appealed and taken to a different court. Hopefully you've also watched some of those videos that I posted reference the different courts. We talked about in those videos what the U.S. Supreme Court does, what the state Supreme Court might do, what the appellate court or the trial court or the district court, and it's important that you know the difference of all of those and how they fall in line in the court system throughout the United States. Well, when a Superior Court case is taken up on appeal, the appeal is usually heard first by the California District Court of Appeal. And we're talking specifically California here, of course. The person making the appeal is known as the appellant and is, in essence, asking the appellate court to consider a question of fact or law with respect to that hearing of his or her case that happened in that trial court. The appellant will usually be the defendant in a criminal action. However, the prosecution may also appeal in some instances, but I mean, they don't always do it, but in some instances they will. Now, when either of the two appellate courts, the state Supreme Court or the District Court of Appeals, makes a decision, a written opinion is filed explaining the reasoning of that court, and some of these opinions are later published. If they contain some novel element, they will appear in the California appellate reports, and that's the rationale for the slide you're looking at right now, where you can look at a case citation published in the California appellate reports would be written as, and here's a kind of an example for you to look at. So I'm not going to spend a lot of time on this. I'll let you look at these two, but that's one way that you can actually look up a section to do a little bit more research. Okay, so next, Attorney General opinions. Well, the California State Attorney General is considered the lawyer for the state, and by law, he or she must give his or her written opinion when requested from certain individuals. And there's a list of those on page 10 in your textbook. So state, senate, or assembly, the governor, secretary of state, controller, treasurer, district attorney, sheriff, city prosecutor, probation, etc., and all of those are in there. Now, the Attorney General is designated as the chief law officer of the state. We kind of already went over that. The formal opinion is registered when question is presented of general statewide interest, and an informal opinion is given on issues primarily of local interest. So basically, there are two types of opinions rendered by the Attorney General. The first is the formal opinion, which I just read. A formal opinion is rendered when it is determined that the question is presented is of general statewide interest. These opinions are printed in a series of publications called the Opinions of the Attorney General. The second type of opinion would be informal and is given on issues primarily of local interest. And it is in the form of a letter sent to the official or organization presenting the problem. These opinions do not appear in published form. However, copies are maintained in the office of the Attorney General, so you can see the two different ones there. Now, the opinions of the Attorney General do not have the same authority as a judicial opinion, okay? And they're kind of regarded, well, they are regarded as quasi-judicial in nature, and therefore meaning they're entitled to great respect, but they won't set case precedent, okay, like some of those other that are maybe a decision by the U.S. Supreme Court. That will be case precedent, as opposed to quasi-judicial, meaning that we're going to give this opinion great respect, but it's not binding, such as an opinion made by a higher court, if you will. So we've talked a lot about the court system, but let's kind of move over to police powers and where do we get the police power? Where does it come from? And are there any things to kind of keep a hold of that police power? Well, the term police power does not appear in the United States Constitution. However, its significance is evident from the authority that the United States Constitution reserves to the states. The police power of the state refers to a much broader area than just law enforcement. The legislatures of the different states, including California, have the inherent legal power to prohibit and punish any act provided they do not violate the restrictions of the federal and state constitution. So states' rights are reserved in the Bill of Rights under the 10th Amendment, which means that they can make their laws. The federal government does not have a general police power as the states do. Okay, the exceptions are laws regarding federal property and military. So police power, again, it's not stated in the U.S. Constitution. It's reserved, the rights are reserved by the state as long as, again, they don't violate the restrictions of the federal and state constitutions as well. So kind of interesting. And the areas of police power you can see under this power, the state can legislate in the following 5 fields. So public health, public safety, there we go, that would be us, morals, general welfare, and economic prosperity. Now, no state, okay, can make any law or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor can any state deprive any person of life, liberty, or property without due process, or deny to any person within its jurisdiction the equal protection of the law. And that's the United States Constitution, and you should recognize that. That's the 14th Amendment. And so just understand that the states can make their laws as long as they don't have conflicts with federal law, or of course the Constitution as well. So now we're going to move on to this thing called the concept of preemption. And the concept of preemption is based on the premise that state law is superior to local ordinances and takes precedent over them when both are concerned with the same subject matter. So you can see here the subject matter is one of the state concern, and the general law occupies the entire field. Local legislation is in conflict with that state law, the subject matter is of such statewide concern that it can no longer be deemed to be merely a municipal affair. So thus, a municipality must exercise its legislative power to enact local ordinances, providing such ordinances are not in conflict with state law or the state has not fully occupied the field of law defined in those local ordinances. So I know that's a lot of legalese, but it is an important concept that we need to understand. Ex post facto laws, well, this one is kind of interesting, but it's kind of simple. So an ex post facto law is one that is passed after the commission of an act and which changes the legal consequences of the act to the wrongdoer's prejudice. And this is prohibited by the U.S. Constitution, Article 1, Section 9 and 10, and also the California Constitution as well. So basically, kind of in review on that, legislature cannot increase the punishment or change the legal consequences of the act to the wrongdoer's prejudice. So an ex post facto law is one which makes a crime more serious, inflicts a greater punishment, or changes the rules of evidence. So we talked a little bit about civil versus criminal. So as we're getting closer towards the end here, let's talk a little bit about crimes versus torts. A crime is an offense against the state. All the people, basically, even though there's victim, is technically an offense against the state and carries a punishment with it, which we should already know what the punishment is. And a tort is considered more of a private wrong, such as failure to comply with the terms of a legal contract, etc. The civil action for a tort is designed to obtain redress, and we learned that term a little while ago, which is payment or reimbursement or etc. Intent is another distinction between a crime and a tort. To render one criminally liable for an act, a person must have a criminal intent as provided under Penal Code 20. So, you know, you can see the difference. You need to have a certain type of intent when you're talking about crimes versus torts. And then a couple of really important terms as we kind of finish up the chapter here. We're getting close, and we'll hit these pretty quick. The term mala in se. For the purpose of this text, it is sufficient to say that crimes mala in se are those serious crimes which are wrong in their very nature. They would obviously include things like murder, robbery, and rape. These crimes are inherently so serious in their effects on individuals and on society that they would invoke almost unanimous condemnation for those who commit these types of acts. Mala prohibita, crimes considered to be mala prohibita are wrong merely because they are prohibited by statute. These are characteristically those offenses which are enacted under police power of the government and for control of conduct like alcohol, beverage control, traffic laws, things like that. Moral turpitude. Turpitude means it relates to that deemed shamefully immoral and suggests a lack of honesty, modesty, and integrity. Crimen falsi means any class of crime that involves falsification. An infamous crime is associated with an act of what they call vileness or moral depravity, like sodomy or bestiality or things like that. And then we're going to finish up with venue, because it really is important that we kind of squeeze this in, because we've talked a lot about the court system kind of and a little bit of structure, but venue and jurisdiction are going to be really important. So venue has to do with the physical or geographical location of the court in which a case is to be filed or tried. Jurisdiction has to do with the court's legal authority over the defendant, jurisdiction of the person, and the crime, jurisdiction of the subject matter he or she is accused of committing. So that in essence is kind of wraps up chapter 1, and I hope that you go on to look at the student review at the end of the chapter, take the true or false student quiz, look at some of those essay the discussion items, because I think they're really important. And then most of all, I think which would benefit everyone would be take that terminology quiz on page 17. So it's the last page of the chapter, and it's kind of that matching quiz that I talked about that will help you kind of look at terms on one side and definitions on the other side, and will help you add some context to the entire conversation that we had. So that's going to be it for chapter 1. If you have any questions at all, remember I have posted in the discussion board area on Canvas. We're not on Blackboard anymore, we're on Canvas. So I posted in the discussion board area a general discussion question area. And if you have any questions at all, you can post a question in there, and either myself or one of your classmates will jump online, because we're so helpful, to answer your question. Or if you don't want to post the question, you can always email me direct using my school email, and I would be more than happy to answer your question, because I'm sure if you have the question, somebody else does too. So that's going to be it for chapter 1. Until next time.